Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, I'm Andrew Flessner with Learn About Law, and today we're going to be talking about what happens if a child is born abroad to a United States citizen and the acquisition of U.S. citizenship for a child born abroad based on the legal situation of that child's family. This question came about because one of our YouTube viewers asked the question, what happens when a U.S. citizen gives birth in another country? This is a great question and serious concern for families traveling regularly for work or visiting family abroad. And media coverage of changes in U.S. immigration policy under the current administration has also led to some confusion on this topic and heightened concern. Generally, there are 5 scenarios with regard to a child being born abroad and acquiring a consular report of birth abroad, also known as Form FS-240. So first, birth abroad in wedlock to 2 U.S. citizens. Second is birth abroad to a U.S. citizen and an alien. Third is birth abroad out of wedlock to a U.S. citizen father under new Section 309A. Fourth is birth abroad out of wedlock to a U.S. citizen father under the old Section 309A. Fifth is birth abroad out of wedlock to a U.S. citizen mother. For reference, in wedlock refers to a child born to its genetic or gestational parents who are legally married at the time of birth or before 300 days of separation of the married parents due to death or divorce. Typically, both parents must also be considered the legal parents of the child at the time of birth under local law. Let's talk about birth abroad in wedlock to 2 U.S. citizens first. This is the most straightforward scenario. A child born in another country in this scenario acquires U.S. citizenship under Section 301C of the Immigration and Nationality Act, INA, as long as one of those parents has had a residence within the United States or one of its outlying possessions prior to the birth of the child. Next, we have birth abroad in wedlock between U.S. citizen and an alien. In the situation of a child being born outside the country to a U.S. citizen parent and an alien, the child will acquire U.S. citizenship if the U.S. citizen parent has been living in the U.S. or one of its outlying possessions prior to the child's birth for the appropriate period of time under current law, INA 301G. As of November 14, 1986, the parent citizen parent must have been physically present for 5 years prior to the birth of the child. Current law also requires at least 2 of those years be after the age of 14 and based on the birth date of the child in question. Finally, the U.S. citizen parent must be the genetic or gestational parent and legal parent for the child under the current local law at the time and place of the birth for the U.S. citizenship to be obtained. Now on to birth abroad for out of wedlock to U.S. citizen father under new Section 309C. When a child is born out of wedlock to a U.S. citizen father, they are entitled to U.S. citizenship under Section 301C or 301G of the Immigration and Nationality Act, the INA. According to the new Section 301A, if a blood relationship can be established between the father and the child in question. The father was a U.S. citizen at the time of birth. Financial support has been agreed to by the father unless deceased for a child until the child in question has reached the age of 18. When the child in question is under the age of 18, the child can be legitimated under the law of his or her residence or domicile. In writing or under oath, the father acknowledges paternity of the child in question. Paternity can be demonstrated by appropriate adjudication of court. So then fourth, we have birth abroad out of wedlock to a U.S. citizen father under the old Section 309A. The old section of 309A of the INA applies to any individual who was 18 or older on November 14, 1986, and to those whose paternity has been established under prior law to the date if the individual in question was at least 15 on November 14, 1986, but under the age of 18, they can have their claim processed under the provisions, old or new, section of 309A. Lastly, we have birth abroad out of wedlock to a U.S. citizen mother. When a child is born abroad out of wedlock to a U.S. citizen mother, or on or before June 11, 2017, that child may acquire citizenship under Section 309C of the INF if the mother was a U.S. citizen at the time of the child's birth and if the mother was living in the United States or one of its outlying possessions for a continuous period of 1 year prior to the birth of the child. In the case of a child born to out of wedlock to a U.S. citizen mother and alien father on or after June 12, 2017, the child is entitled to citizenship if the mother was a U.S. citizen at the time of birth and living in the United States or its outlying possessions for a continuous period of 5 years, or 2 after the age of 14 under 301G of the INA. The U.S. citizen mother must be the genetic or gestational parent of the child and the legal parent in all cases under local law at the time and place of the child's birth. This information covers the 5 scenarios for the citizenship transfer when a child is born out of the country. Thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com. Call us at 630-324-6666 for a free consultation.